The meeting of the Criminal Law Subcommittee for January 17th will come to order. First, some administrative details. Despite my kind of frowning at them, we have two members who have asked that their bill go by. The first one on the docket, HB 1643, Hayes, having to do with dismissal for proof of compliance with law of traffic, et cetera, will go by. There are some amendments that are needed and they're being worked out. On HB 2063, Garrett, he has asked that this go by for the day. So that leaves then, and also Delegate Milday, HB 1558, has asked that it be incorporated in HB 1946 that is also on our docket, both of them having to deal with the possession of tobacco and hemp products by people under 21. May I hear a motion to incorporate HB 1558 into HB 1946?
So move.
Second.
Any discussion? Is this a recorded vote? Mr. Uberchair, is this a recorded vote? Let's do a recorded. Please open the roll. Please cast your vote. Okay, that means those announcements then leaves us with only one member of the House who is not on this committee, who is here to present, and I would like to recognize Delegate Gardner, who is presenting HB 1955.
Good afternoon, Madam Chair. Is it on? Okay, good. Let me know when you're ready. Ready?
Before you begin, Delegate Gardner, as you're collecting your thought, Madam Clerk, would you open the roll to take attendance? Members, cast your presence on the board as it opens. Can we do it? Okay. Please indicate your attendance. Close. Williams, do? I think we have everyone, and Uber Chair is also here, Hope. Please close the roll. Thank you. Now, Delegate Gardner.
Thank you, Madam Chair, members of the committee. HB 1955 before you is a bill that will eliminate the sentence disparities between crack and powder cocaine. In the 1970s and 80s, many states and the federal government enacted sentencing laws creating a disparity between penalties for crack cocaine and powder cocaine offenses. Crack cocaine and powder cocaine are two forms of the same drug, and there's no scientific basis for treating them differently under the law. Even so, Virginia's criminal code imposes the same 5-year mandatory minimum for an offense involving 500 grams of powder cocaine as it does for 250 grams of crack cocaine, and 20-year mandatory minimum for offenses involving 5 kilograms of powder cocaine and 2.5 kilograms of crack cocaine. The Commonwealth of Virginia is one of only 6 states that continues to treat crack cocaine more harshly than powder cocaine. Imposing different sentences for the same drug creates inequity and undermines public trust in the criminal justice system, which is detrimental to public safety. There is no significant basis for treating crack and powder cocaine differently. They are the same drug with similar risks, including addiction. Many states have already eliminated it, leaving Virginia, Maine, New Hampshire, North Dakota, Arizona, Iowa. And recently, the federal government was passed it and eliminated the disparity. Equalizing crack and powder cocaine sentences does not harm public safety. After reducing the federal disparity, recidivism rates for those with reduced sentences were similar to those who served very long sentences. This change will increase public trust in Virginia's criminal justice system by making it fairer, more equitable, and demonstrating the legislature's commitment to public safety. I ask that you consider passage of this legislation. And we actually have someone online who can answer any technical questions for you. We also have the support of the Virginia Commonwealth Attorneys Association. Thank you.
Thank you, Delegate Gardner. Did you wish to have your individual online speak to it, or are they just speaking to the bill?
They can answer any technical
All right,
questions
we
you may
may
have,
need to
as
call
well
them.
as they want to speak to.
Does the committee have any questions of the bill as presented? Seeing none, I think we've all very much aware of this issue. Is there anyone in the room speaking for HB 1955? If you would all stand up at the same time so I know how many, 2 minutes apiece, please.
Yes, Madam Chair, members of the committee, my name is Brian Haskins. I'm the Commonwealth Attorney for Pittsylvania County. I'm here on behalf of VACA to say that Delegate Gardner is correct. VACA does support this bill.
Thank you.
Good afternoon, members of the committee. My name is Chida Innes. I'm a legislative strategist with Prison Fellowship. We're the nation's largest Christian nonprofit serving currently and formerly incarcerated people, and we support the bill.
Thank you.
Madam Chair, members of the committee, Rob Hogenclass, Executive Director of Justice Forward Virginia. We're started by a group of public defenders to have a smarter justice system in Virginia, and we support the bill. Thank you.
Thank you.
Hello, Madam Chair, members of the committee. Dominic Martin, New Virginia Majority, and we support the bill.
Thank you. Is there anyone here speaking against 1955? If not, online we have 4 individuals who have signed up to speak. Well, 3 have signed up to speak for the bill. The first one is Daniel Landsman. If you would keep your remarks to 2 minutes or less, thank you.
Thank you so much, Madam Chair and members of the committee. My name is Daniel Landsman. I'm Vice President of Policy for FAM, and we are in strong support of House Bill 1955. Thank you very much.
Thank you. The next speaker is Mrs. Fatima Mahawed. My apologies for mispronouncing your name. Please, 2 minutes or less.
Thank you, Madam Chair. Fatima Mawahed with the Humanization Project, and we strongly support the bill.
Thank you. And the next speaker is Ashley Crocker from Progress, Virginia.
Hello, my name is Ashley Crocker with Progress Virginia, and we strongly support the bill. Thank you.
Thank you. And then we have a final speaker who is registered with no position, speaking from the Virginia Coalition Against Human Trafficking, Jacqueline Goad. Jacqueline?
Yes, I'm sorry. I signed up for 1968. I am very
I
sorry.
will record that. Thank you. Stand by.
Thank you. Will do.
Okay. Are there any further questions of the patron? You have the last word before we take action.
Again, Madam Chair, members of the committee, I really believe that this change will increase the public's trust in our criminal justice system, and I ask that you pass this bill.
Thank you. We operate by motion.
Okay.
Been moved and seconded. Are there any discussion? If not, clerk, please open the roll. Members, cast your vote. HB 1955 passes unanimously to recommend reporting 8-0.
Thank you, Madam Chair and committee members.
And now I did miss, we have Delegate Oates also with us, and Delegate Oates is presenting HB 1839.
Thank you, Thank you, Madam Chair and Committee. Thank you so much for allowing me to present today. This bill, HB 1839, allows for one additional person at the discretion of the judge to be allowed in evidentiary hearings for the support of the complaining witness in a rape shield proceeding. I actually had this bill last session, and we addressed the concerns of this committee, and hopefully it is in a posture now that it would be moved to report. The primary points is that victims of sexual offenses sometimes feel great nervousness, anxiety when they testify in a criminal court. To ease such feelings, a family member, psychological counselor, or other person can accompany the witness in testifying. However, this would provide the victim support system to remain in the courtroom during an exceptionally invasive and deeply personal court hearing. The goal is to give victims an empowering experience that helps their healing and does not contribute to re-traumatization. Recognizing the trauma that some witnesses and victims experience, this bill is in line with modern trauma-informed practices in the legal system, which emphasizes minimizing the re-traumatization and ensuring a compassionate approach in courtrooms. The bill empowers the judge to assess whether or not the presence of a supportive person would impair the fairness of the hearing, thus preserving judicial discretion and allowing for case-by-case evaluations. This combats the issues that were discussed last legislative session as to the potential implications for courtroom procedures, fairness, and the protection of involved parties. So if it be the will of the committee.
Are there any questions of the patron? Delegate Delaney.
Thank you, Madam Chair. And Delegate, this could be a question for you or maybe anyone else in the room that kind of works in this environment. You know, obviously this is an area I'm really sensitive to as well, so I appreciate, you know, your efforts in trying to make a more trauma-informed environment for people that are going through a difficult situation. I guess one of the kind of questions and concerns that I have is around how we're establishing that this person really is in the best interest. Sometimes when we're dealing with these types of crimes, people who may appear as a support person may actually have more to do with that victim's victimization than we may know. And there can sometimes, I think, just be it can be very hard to tell if someone who looks very supportive may actually have a hold on that person that we may not see. And if we're putting this into the discretion of the judge, is the judge qualified to make that kind of assessment? And if it's not the judge, who would be the person to kind of look at the full scope of that dynamic and be able to recognize that, okay, this very supportive seeming mother may actually have been complicit in this child's trafficking, for example? How is that conclusion reached?
That's a great question, and at this point, my understanding is the judge is the person who will make the determination if someone should be allowed in this proceeding, and they determine it. Would you like to speak to that? Thank you.
Good afternoon, Madam Chair, members of the committee. My name is Carrie Kohler. I'm a Senior Assistant Attorney General here in Virginia. I have worked as a prosecutor for about 18 years and have had some experience with victims of rape and other sexual assault. I think the concern that the delegate has could be defrayed by having not just that the victim selects their person, but also having the victim advocate who is with this person each step of the way and accounted for in other proceedings. This is the only proceeding where they are required to attend alone.
But Madam Chair,
yes, Madam.
The way that the bill is constructed, it would not just be limited to professionals, but also potentially family members or close associates who, you know, other people that might be, and I can certainly recognize situations where that could in fact be incredibly helpful. My concern is, you know, just anytime you're kind of adding another layer of influence or what you might be nervous to say in front of that person's presence. Just not knowing how to strike the balance between the emotional support that's afforded and then the quality of whatever testimony may be given when you may have an undue pressure from someone that you don't always know exactly what the influence they may have over that individual.
May I answer? I think in that case, we do have to trust the discretion of the victim who is going to be testifying to select the proper person, to relay to the victim advocate, to relay to their assigned prosecutor that that is the person that they feel most comfortable having with them in that proceeding.
If I may follow up with a question, you have referred to the victim advocate. We have a new system on and it's a little harder to read the language of the code that compared to what I've experienced before. Where is the victim advocate required to be in the room? Is it still another person?
Pardon me, they are not required to be in the room for the rape shield motion. In fact, it is a closed proceeding only to the parties and necessary court personnel.
So if I may proceed then, so your reference to victim advocate has been prior to this, so the victim still, the alleged victim is still can say that I want this person in the room.
Yes, this change would not preclude the advocate from being the select person.
Thank you.
Question for the patron. No problem. Question for the patron. So you hear the concerns that they're bringing up about discretion and potential influence. Would you be amenable to an amendment that would allow for professionals to continue on and remain in the courtroom rather than, say, family members and others that might have influence over the children or victim?
I would be amenable.
Thank you, Madam Chair.
Are there any other further comments, questions? If not, I'm sorry I didn't have my mic on. If there is hearing no, counsel, do you have anything to add?
Madam Chair, just point out a couple issues I think I see in the bill. The first is that this bill was originally modeled after something that's already been in the code. It's been there since 1981, the closed preliminary hearing. However, that applies to both the complaining witness and the accused. So this only applies to the Commonwealth prosecution side of things, allowing these support people in. That's my first issue. My second issue is, and it sort of dovetails from the discussion that we're having about who's the right person, is, as it's written, the Commonwealth can just show up, or the witness can just show up with somebody and say, I want them to be my support person. There's no ability for anybody to look into this prior to the hearing, and the judge has to make a decision right then or continue the hearing. And so I think if this goes any further, it needs to have a notice provision so that anybody who intends to use this support person should have to be able to give notice to the court and the other side, so that they can be prepared to either argue for or against it, or be able to show to the court that discretion is that it is the proper discretion to allow this person in.
Thank you. I appreciate that input. Are there any other further questions? If not, let me open it up then to testimony. People here in the room who wish to speak for, please stand and come to the microphone. And we have 2 minutes apiece, max. Thank you. Please come forward and identify yourself.
Thank you, Madam Chair, members of the committee. I'm Brian Haskins, the Commonwealth Attorney for Pennsylvania County. First, say that VACA supports the bill, and I don't want to take up too much time because I know the other individual may have a more personal story. I've handled many of these. I've been prosecuting for 26 years. I defended for 5 years before that. I've been on both sides of this issue. The whole purpose of the rape shield hearing is to protect the victim, and I'll tell the court why. Because the rape shield hearings almost invariably involve, well, I'm going to accuse you, ma'am, of being a loose woman and having sex with John and everybody else. And those things were usually just thrown out in the middle of a courtroom full of jurors, and it embarrassed victims, and they didn't want to come forward because of that. The rape shield hearing allows the defendant to have a full hearing on that issue where the victim is protected from these kind of salacious rumors being circulated in the public. The fact that the victim would like to have someone there sit with them is not going to be somebody who's going to perpetrate these rumors out in the public. So if someone comes in and says, well, I want to say you had sex with John the week before, therefore you must be a loose woman and had sex with my client voluntarily. That's the whole purpose of the rape shield hearing. As the Commonwealth attorneys see it, we would like to have a victim have someone there other than a strange man, that's myself, that they've met a few times, who said, I'm Mr. Haskins, nice to meet you. Let's talk about how the sex that was forced upon you. It's already embarrassing enough and to talk with me about it. We would like for them to have someone there, because the purpose is not to impeach them or influence them. The purpose is to have someone there that makes them feel comfortable to give this testimony and to answer these very embarrassing questions in a fashion where the media is not going to be printing it. The last thing I'll say about that is these people you're talking about that are influencing are going to be allowed in the trial anyway. This is just a hearing to have these questions answered under oath for the judge to decide whether the evidence will be relevant in a trial. That same person you're worried about might be trying to influence them is going to be allowed to sit in that public courtroom anyway, and the judge is the one who has the discretion to decide whether they're influencing. I'm sorry I've taken up too much time. Thank you. I would ask that you allow this young man.
If you'd please come forward.
Madam Chair and the members of the committee, my name is Samantha Solar. I'm a rape survivor, and like many before me and after me, I was part of Rape Shield, a law put in place to protect me and others like me, but the fact of the matter is the law does not. After my rape, I was alone, shattered, and vulnerable. A man who didn't know me painted a narrative and tried to portray me in a disgusting, negative light, while I was forced to stare at an empty courtroom feeling traumatized all over again. Rape survivors should not have to be victimized by their attackers over and over again, with the help of a law enacted to protect them. Rape survivors should not have to be forced to be alone and traumatized any further by their attacker. Having someone in their corner and present in the courtroom or disposition process may seem simple, but it makes a huge impact when you feel as if you are all alone and have no one. I am asking you to pass this bill so that rape survivors like myself will no longer have to sit in a courtroom alone during a rape shield hearing. Having a support person present would have given me so much more strength, and I would not have been reminded that I was alone. Thank you for hearing me today.
Thank you very much for your strength to come forward. Is there anyone in the room speaking against the bill? And online, we have speaking on HB 1839. We have one person speaking from the Virginia Coalition Against Human Trafficking, Jacqueline Goad. I know she was not on before, so let us just proceed forward. Delegate Oates?
I would thank you all very much for hearing the presentation of the bill, and I would appreciate if you would report. Thank you.
If I may, as a prerogative of the chair, make the statement of concern. Certainly, council brought up issues as far as the defense, because we've all lived long and complicated lives, and we're certainly aware of situations where we also have perhaps representation of defense not in the room with the same. We have the issues of how you determine the whether or not, since there's no prior notice, all of these procedural things. I know, again, from having worked a great deal with child victims of sexual abuse, the issues of influence of family members and how you penetrate that. There are many, many issues that I think are raised on this bill, despite the concept that you are trying to arrive on. With that, I would ask as chair prerogative for a motion to go by for the day as we see whether or not we can work through these issues.
Second.
Hearing it moved and seconded that the bill go by for the day, all those in favor say aye.
Aye.
Opposed? Thank you very much for the presentation.
Thank you, committee.
The next bill then on our docket is I would rather do, because Uber Chair Hope, yours is perhaps a little more complex, so let's and there are probably more in the room on this one as well.
Hi, Madam Chair. I know from Delegate Milday had a similar bill.
And that has already been incorporated into your bill.
Yeah, and I know that he has a speaker here. So what I'd like to do is I'll explain a little bit about my bill. There's going to be a substitute, I think, is what we're going to have, and I'll ask the Ledge Council to walk through some of this.
And if I may officially announce, the bill is HB 1946.
1946. Thank you, Madam Chair, members of the subcommittee. The bill tried to accomplish two things. One is it builds off legislation that we passed last year to create a licensing system for retail and vape shops that are selling to underage. And so it starts to enforce our laws of underage smoking, tobacco use purchases at the retail and vape shop. And so this was an oversight that we thought that in repealing the penalties against kids that are in possession or buy the tobacco products, we certainly didn't mean by any case that if they're caught, that the item could not be confiscated, whether at school or whatnot. And so what we did here is the bill does two things. One is it clarifies that anyone in possession of nicotine vaping products, it can be confiscated, number one. And number two, I was contacted by the Department of Taxation to ask for some technical amendments that are included in the bill to allow some communication between tax and Department of Behavioral Health to make sure that they're tracking where these vape shops are so that there's going to be communication, because what's tied to the licensing scheme is tax. And obviously we know if they're paying taxes on cigarettes and tobacco, we know exactly where they are so that they can conduct these investigations. So I'm going to turn it over to maybe Mr. Hatcher or Mr. Mutnick to explain we've narrowed the legislation a little bit to make it very clear that we're only talking about confiscation here, and that's it, and that can be confiscated and the rest will stay as is. Mr. Hatcher.
Yes, Madam Chair, members of the subcommittee. The substitute has been posted online and been distributed before you all. One technical change to the substitute is it adds code section 15.2-912.4 to the bill to update a necessary cross-reference. These are just technical fixes that were missed in the bill last year. And then the second thing that this bill does, the substitute does, is changes subsections B, C, and D of the new code section 18.2-371.2:1 on lines 37 through 44, which now shows a seizure and destruction process for possession of such products that I will let outside counsel Mr. Bunick explain the importance of.
Madam Chair, originally the bill had a seizure process that was modeled after the forfeiture process that we use for every other contraband when it is something that is tied to a actual criminal offense. It required filings in the circuit court and a long drawn out process in order for this, for a officer or somebody to seize this product and destroy it. What we have done is cross-referenced the code section where we do the destruction of controlled substances, which doesn't require a drawn-out seizure process, but just requires a court order down the road to destroy it. But the seizure is legal upon coming upon it as an officer. Section C has the seizure of the contraband as the sole penalty. That is done because of Code Section 18.212, which says that if there's not a penalty set forth, that it automatically becomes a Class 1 misdemeanor, and nobody wanted that to be a jailable offense. And so this clarifies that there is no penalty other than the seizure of the contraband. And then we do have a further, I think. Okay. And then after the substitute's adopted, there's a further amendment that needs to be made to the substitute.
So again, members, you have the substitute language that was being referred to before you. A motion is in order to adopt the substitute.
Move to adopt the substitute.
Is there any discussion? So as I understand the discussion, essentially you are reflecting, if you will, standard operating procedure with some of these agencies in the bill.
Yes, Madam Chair.
All those in favor of adopting the substitute, say aye. Aye. Opposed? Okay. The substitute is before us.
Madam Chair, there are additional technical changes, a drafting error with the substitute in front of you on lines 22, 25, 34, and 38. We're going to strike any references to purchase or attempt to purchase. This bill will only reflect an individual under 21 that possesses the hemp products or the retail tobacco products. So if the committee would like those amendments.
Attempt to purchase and purchase is struck. So prohibiting possession of retail is all they will now read.
Correct. It's just a technical drafting change.
Madam Chair, I move the line amendments as described by council.
Any discussion? All those in favor say aye. Opposed? Thank you.
Okay. Madam Chair, and thank you for that. So that's the bill before you. I explained it earlier, exactly what was already substituted. I know that there are people here to testify for the bill, and I'll yield.
You're in control of presenting your bill.
Good afternoon, Chairman Watts and members of the committee. My name is Deontay Diggs. I'm a lieutenant with the Stafford County Sheriff's Office. I've been with the office now 16 years. Approximately half of that time I've worked with Juvenile Services Unit in some capacity of either supervising or working in the schools themselves. We currently have 23 members of our School Resource Officer program. I'm speaking in support of House Bill 1558, and my comments are also relevant for House Bill 1946. The use of tobacco and vapes in our schools is a significant problem, health concern as well. For our Sheriff's Office, we are addressing the issue through our Special Problems Unit of businesses selling to minors, but where we've seen the biggest issue was when the civil penalty was removed, the use on our school campuses. Before the civil penalty was removed, what would typically happen is the student would be caught with tobacco or vapes. The first offense, the school would handle it. The second offense, the sheriff's office would get involved, file a petition, which was diverted. But both the student and the parents were then, by juvenile intake, asked to attend or mandated to attend an educational class. Once the civil penalty was removed and students started to figure this out, what we've seen is an increase in use on school campuses, and the juveniles aren't, some juveniles are not modifying their behavior, even when the schools are suspending them. It's just, they feel like they're getting a day off, so to speak. And so what we're asking for from the law enforcement lens is that we have the ability, again, to address this, not that we're trying to ruin juveniles' futures or put a bunch of charges on them, but that we have a way to mandate that both the student and the parents are attending some type of educational process. Thank you.
Thank you. The next speaker, please.
Good afternoon. Elizabeth Hobbs with the Virginia Sheriff's Association, and we are in support of the bill.
Thank you. The next speaker. Is there anyone, yes, speaking for the bill? You have.
Well, I'm nuanced, so.
Well, if you'd like to come forward and address the committee, please. 2 minutes.
Yes. Madam Chair, members of the committee, Kelly Fitzgerald representing the American Heart Association and the American Cancer Society Cancer Action Network. I wasn't planning on getting up today to speak for Delegate Hope's bill. We do have concerns in regards to Delegate Mills' bill. Now that they've been rolled together, we'll have to look at that before we can take a position. But did wonder if it was appropriate today at least to register our concerns in regards to Delegate Mills' bill, if that's appropriate.
Would you please? Again, that's the bill we are hearing.
Okay. We appreciate Delegate Mills' time as we met with him and laid out our concerns, and we absolutely appreciate his interest in the problem of youth tobacco use. As public health organizations, we feel that purchase, use, and possession laws do unfairly stigmatize children and shift the blame from where it should be with the people who have allowed these children to get their hands on these products. We absolutely understand and sympathize with our amazing law enforcement community here in Virginia. This is a problem. But again, there are other ways to get at it before we start penalizing children that often come while they're battling addiction to these products. There are things like flavor bans, things that makes these products less enticing to kids, and other things that make them harder to purchase. I would say before we even start to think about penalizing children, we have to say that we have exhausted all other regulatory and legislative options to help them. And to date, there are some left that we could still explore in Virginia before we head down this road again. So thank you for your time again, and we appreciate Delegate Mild and Delegate Hope's interest in youth tobacco use. Again, we agree it's an absolute problem, but we do think there are other ways to potentially get at it before we start down this road. But we will be looking forward to working on this bill with them both. And thank you for your time allowing my comments.
Thank you. Is there anyone here speaking against HB 1946? The only person I have signed on online is, again, the same individual from the Virginia Coalition for Human Trafficking. And do I understand she's off totally on all the bills?
One bill.
Just one bill, and you'll identify that.
I sure will.
Thank you. Appreciate that. Senator, excuse me, Delegate.
Promote me.
Delegate Hope.
Thank you, Madam Chair. I did want to respond to the previous witness. She's right. We don't want to penalize the kids, the underage. And that's what the last year's bill did. It repealed the penalties, the civil penalties. I think everyone just needs to be absolutely clear. We're not putting penalties in this. We wanted to come back and say, look, if law enforcement or at school, you caught kids, I mean, I have kids in high school. They tell me all the time kids are vaping in the bathrooms. If the teacher goes in and sees them doing that, the principal sees them do that, the security officer, SRO, whatever the case may be, we want to make clear that that can be confiscated. We're not looking to bring these kids into court. There's no civil penalties attached. The only civil penalties that are existing under current law is a $25 penalty that is already existence for possession of tobacco products underage, or anyone for that matter, $25 underage at school or at school functions. And so that will remain in effect. And so we're just limiting this to a confiscation. There's no civil penalties. No one appears before a court or a judge, no community service or anything like that. I will say this, however, and this is something that Delegate Mildy had in his bill, I had in my original bill, but it was struck out, is you come up and see a number of kids that are doing this over and over. There's a good chance that they're addicted, and that's why they're doing it. They do it just to feel normal because that's the nicotine high. They may need some help. I'd like to figure out a way if you can have these multiple offenses where you can have this tobacco cessation program. I met with the advocates. It doesn't seem like we can do that in the law, but it's something that I'd like to work towards. If the subcommittee wanted to act favorably on this bill, I would want it to go to Appropriations Committee. I can't believe I just said those words, but I would like to have it to go upstairs. My promise to all the advocates on both sides of this issue is to continue working on this. But I think we're very, very close here with the confiscation because that's what the problem I wanted to solve.
Thank you. And at this point, I broke my own rule that I made for myself was before you got the final word, so you still get another final word. I always wanted to ask counsel if you have any comments on the content before us.
Madam Chair, now Delegate Hope and I spoke yesterday about the issues that I had, and they've been addressed in the substitute, and so everything is good on my end.
Thank you.
And one more thing, Madam Chair, if I may. I don't want this to be a situation where we are, because we've had this in previous legislation before, where we are putting kids in a position where they get unwanted searches or anything like that. And so we certainly want to avoid anything like that. I don't think there's anything in the bill that would make me think that, but some people have brought up to me that that might put them in that situation, and I certainly want to avoid that. But I don't want to bring up pretextual stops again, but that certainly was something that's of concern to me. I don't know if council has any magic words to put people's mind at ease, but we just want to create a situation where you're caught with it, it can be taken away. And I just want to make that very clear in the law, that repealing the possession and use and purchasing was not our intent, to just to allow you to have it.
Thank you. Any questions, comments from members? If not, a motion is in order to recommend reporting and referring to appropriations, the substitute as amended. Anyone wishing to speak to the motion? I will only speak to the motion in an ongoing determination I have that when something goes up to appropriations, please, please, please try to preserve that the changes that we have discussed today will be changes that will be reflected in the code and not just in budget language, please.
Yeah, you have my word, Madam Chair.
It's a battle.
That's not why it's going up there.
If there are no further comments, yes, Delegate Delaney.
No, Madam Chair, I was just going to make the motion at the appropriate time.
I thought it had been made.
Okay, if it has, to clarify, I'm happy to make the motion as, is it a move to report and refer to appropriations as
substituted?
Substitute as amended.
Any further comment? If not, clerk, please open the roll. Members, cast your vote. And HB 1946, we recommend, again, to repeat that whole litany, that it be substitute as amended, be reported and referred to appropriations.
Thank you, Madam Chair.
Thank you. Remaining on our docket, then, we have two bills. House Bill 1960, well, in numerical order, we'll go 1873, Coulson, release of the accused on secured or unsecured bond.
Should I just start?
You may.
So Chair Watts, I do have an amendment in the nature of a substitute, but I think it might be better if I can explain the intent of the bill, because a substitute is basically a fix that arrives us at that.
Right.
Okay. So this is a VCJC bill, and what it is accomplishing is the fact that right now, if you have certain pre-existing conditions, if so, you can read them in the bill. If you have a previous arrest for a felony, if you're on bond, if you are on probation or parole, I should say bond for an unrelated felony arrest, then when making a determination about whether you get secured or unsecured bond, it is mandatory that the judge give you secured bond. And so the intent of this bill is to say that rather than do that, let's put discretion back into the judge's hands in order to look at the host of determining factors that decide whether or not you need a secured or unsecured bond. So I will talk about the bill more in just a second, but there was today a little bit of a hubbub. I feel like we're all feeling this short session, and so there was a realization that the previous language didn't do that as well as the new language. So we are putting forth a substitute, which I would gladly ask staff to explain.
Thank you, Madam Chair and Delegate Coulson, members of the subcommittee. The substitute has been posted online. The substitute makes changes to Code Section 19.2-123, where Delegate Coulson was referencing those factors. They were kind of piecemeal stricken in that section in the introduced bill. What the substitute does was strike all of that language and simply starts with when a person is arrested, and the code section follows with the rest of the subdivisions. And I will note that it does appear that in 19.2-120, the factors are added about a person's bond status for unrelated arrests and person's status on probation or parole are in that section for the judge to consider.
Mm-hmm. If it's Chair Watts, if it's the will of the committee to accept the substitute.
Excuse me, before I ask for a motion on this, I have before us, again, Okay, I'm looking at the wrong piece of paper here. Right, here we go. It's 1873. 1873. There we go. So 1873 then is an amendment in the nature of a substitute, and I and now everybody else, or I am now joining everybody else having it in front of me. Is there a motion on the substitute as reported?
Move the substitute.
It's been moved and seconded. We adopt the amendment in the nature of substitute. All in favor say aye. Aye. Opposed? It is now before us. Do you wish to speak further to it?
Yes, please, Chair Watts. So, Chair Watts, I think one thing that is important to note is that this, again, it's a VCJC bill, which I feel like I'm explaining to people who already know, but that is a committee that gathers judges, defense lawyers, prosecutors. I think there's a representative from the Indigent Defense Commission. There's also someone from the AG's office present, although I don't think they're a voting member. They're all there to brainstorm solutions to what they recognize are problems in our criminal justice system. And this was recognized as one. This solution, this conversation is not about dangerous people. Dangerous people don't get out on bond. It is about the determination of whether you're going to let someone free, regardless whether you make them pay money to go free or you don't make them pay. And we have a list of factors that judges can look at to make that determination, except for if you're this type of individual, then you don't get any of those determining factors. And in fact, you get cut off from some other non-monetary conditions that could be placed on your release and potentially help these individuals. So you have to sit in, if you can't pay bond, you have to sit in jail, you might lose your job, versus the judge being able to say, hey, you're not actually a danger, you're not a threat of running away, you can get out and you just need to maintain your job, refrain from using alcohol, and whatever other conditions they want to be placing on them. So that is what the bill is hoping to accomplish. I didn't want to, it also does not get rid of the judge's ability to do a secured bond if that's what they want. And it doesn't get rid of their ability to consider their criminal history. In fact, that is considered, and I wanted to make that clear, which is why we moved those conditions back up into the list of what they can consider. It just gets rid of the mandatory, it's not even a presumption, the mandatory requirement that they get secured bond if they have a previous felony. And I will note that is regardless of time of that felony. So if you have a felony for like possession of marijuana that's 30 years old and you're now in front of a court and you can't afford, automatic secure bond. And I just don't, that's the bill in a nutshell. I have people who are better versed than I. We have Doug Ramser, I hope I'm pronouncing that right, from VCJC, who can answer technical questions, and I think we have some people here with testimony.
Thank you. And before we turn to the individuals, as in call a friend, Counsel, do you have any concerns that you wish to raise so they might be also addressed at the same time?
Madam Chair, again, I spoke with Delegate Carlson yesterday about my concerns with the bill, and they've been addressed in the substitute.
Thank you. Delegate Carlson, you want to bring forward others to present the bill?
If anyone has questions.
Or do you want to speak, or do you simply want to speak in favor of the bill?
Thank you, Madam Chairman. My name is Doug Ramsor, and I was co-chair in the VCJC of the committee that recommended this fix, along with Joe Platania, who's the Commonwealth's attorney for the city of Charlottesville. And like Delegate Carlson has said, VCJC works by consensus. So the bills that come out of there are ones that the entire group has come to a consensus that we believe is appropriate for a fix. The problem that we have currently right now is not whether or not someone is appropriate for bond or not. It's whether or not it's going to be mandated that they have to have a secured bond that is paid a bond. And a judge, and there might be a situation where, let's say someone who had a felony that is 30 years old gets arrested or gets charged with some offense, and they come in front of a magistrate, let's say on a Friday evening in some jurisdiction, and the magistrate may find that this person is perfectly appropriate to be released on bond and would maybe even have given them an unsecured bond, so they could do that. But this code section prevents them from doing that without having a prosecutor agree to that, and prosecutor may even be on duty in certain jurisdictions. And that person is not going to be held over the course of that weekend. And they could give them a de minimis bond. They could give them a $5,000 secured bond. But for many people who are not of means or are poor, that's enough to hold them, and they can't make that, right? Someone who's wealthy, they can make that, no problem, have plenty of money, but someone who's poor can't. Now that person's going to be held, certainly over the course of the weekend, and they may not even get in front of a judge until several days later when the court's sitting in the rest of that week. And when they get to that situation to have that bond considered, The judge who hears it also cannot give an unsecured bond. Whether it's a general district court judge or a circuit court judge who might believe they're appropriate for that can say, sorry, I still have to give you a monetary bond before I can let you go under this code section with no discretion whatsoever. They could give them a bond. It's just a question of whether we're going to require people to pay money or not when it's appropriate for that. And really what happens now is it only affects people who are poor and cannot afford to pay for a bond themselves. This is not a decision, like the delegate said, of whether they're appropriate for bond or not. The judges still have that discretion. It's, are we going to make them have to pay? And then the only people going to get held are poor people who can't afford it. And that's not how this should be. And we should give discretion to the courts to make those decisions.
Are there any questions of the representative of the Virginia Criminal Justice Conference? If not, is there anyone else that you wish to have present the bill? Otherwise, anyone in the room who is speaking for the bill, please come forward. You have 2 minutes.
They're looking at me. I'm like, yeah,
Come on up. Good afternoon. My name is Tim Coyne. I'm the Deputy Director of the Virginia Indigent Defense Commission. Not speaking to you on behalf of the commission, however. Previously, I was a public defender in the city of Winchester and surrounding counties for 18 years, and also a member of VCJC, and they do very much operate by consensus. I'll reiterate everything that Mr. Ramser said. I would simply add, in rural jurisdictions like where I practiced, it might not just be over the weekend. It could be 10 days for somebody to be held because the courts don't sit every day. And so in that time, even if somebody's held on a $500 secured bond, that's unattainable for some folks. That's being held without bond. They can lose their jobs, their housing, et cetera. So it does have impact and import. Again, we're talking about affecting people who otherwise would be eligible. They're not a danger. They're going to show up for court. It's just a matter of the conditions of their release, and this puts it back in the hands of the judicial officer. Thank you.
Thank you.
Madam Chair, members of the subcommittee, Rob Hogenclass, Justice for Virginia. Nothing to add, just align myself completely with Mr. Ramser, Mr. Coyne. Thank you.
Thank you. Is there anyone in the room speaking against the 1873? And I think that we do have someone online on this one. Thank you. 1873, speaking for it. We have.
Madam Chair.
Yes, I'm sorry. I'm sorry, please, in opposition. My apologies, sir.
That's fine. I'm Brian Haskins, Pennsylvania County Commonwealth Attorney's Office, Madam Chair, members of the committee. I'm not here speaking on behalf of VACA. They have not taken a position, but I want to make sure we understand fully what the change is, because what came out of VCJC was a compromise that took away the mandatory secured bond for someone who has been convicted of a felony in the past 30 years ago, as Mr. Ramser pointed out, but kept it for anyone who was already on bond for a felony when they commit a second felony somewhere else, a new felony offense, while they're already on bond. And this language takes all that away and says that no one is required to have a secured bond, but it does, as the delegate has very succinctly stated, keep the discretion for the judge to decide whether somebody needs a bond secured or not on a felony or a misdemeanor. I just want to make sure I didn't hear that explanation. I just want to make sure we're taking no position. I just want to make sure we understand what the bill's doing.
If I may ask, counsel, would you agree with that interpretation?
Madam Chair, I think that I wasn't at VCJC, so I don't know what the compromise was, but the language as it was in the original bill, in my opinion, would cause more people to be required to be on secured bonds, because it also got rid of the ability for the court and the Commonwealth to waive that provision. So it would be that any person who got arrested that was on bond for a felony would be required to have a secured bond, even if everybody wanted to put them on an unsecured bond. So I agree that the substitute now restores the complete discretion in the court of what conditions to be placed on somebody's bond. Those who are not a candidate for bond under the factors that are listed in 19.2.120 will not get a bond, and those who are a candidate for bond will get those with the proper personalized factors to keep them safe, the community safe, and that make sure they come to court.
Thank you. And now I'd like to turn to online. We have the representative of the Humanization Project, Fatima Mahawit. I'm still not saying it right.
Thank you. Madam Chair. It's Muwahid, but that's all right. I'm Fatima Muwahid with the Humanization Project. I'd like to thank Delegate Carlson for proposing this bill. We support this because our communities are stronger when we find ways to avoid the collateral consequences of incarceration before someone is even convicted. This only is relevant to people being offered bond. It simply means that when you qualify, you'll be less likely to have to stay there before a conviction just for being poor. When this happens, it creates collateral consequences. Just a few days or a week leads to lost homes, lost jobs, and family separation. We have seen it time and time again, often when people have the initial charges dismissed entirely eventually anyway. Still allows for secured bonds too, but gives the discretion to the judge, which are several reasons why we support it. Thank you.
Thank you, Mrs. Mohahid. Are there anyone else? Any questions? You have the last word.
I, at the end of a long week on a Friday, don't have many more words to offer. I'm happy to answer questions if anyone has them.
Thank you, Delegate Colson.
Second.
Any discussion? There's been a move to move the substitute. It was not amended to move the substitute for HB 1873. Hearing no discussion, please open the roll. Members, cast your vote. There it's everyone recorded. Okay, HB 1873, we recommend reporting with substitute by a vote of 5-3. The last one then on our docket is now Delegate Delaney, 1968.
All right, I'll go down here because I know some folks are
Not a problem.
So I'll stand with them.
Thank you, Madam Chair. I have House Bill 1968, and I do have an amendment to introduce.
Yes, Madam Chair, members of the subcommittee, the line amendments have been posted online and distributed to you. There are 4 of them. On line 62, after the word police, inserting or court. Line 65, after the Romanet 1, inserting any police records, semicolon, Romanet 2. Line 66, after situation, inserting a semicolon, and line 66 introduced after and, striking the Romanet number 2 and inserting the Romanet number 3. These amendments would clarify that for consideration of an award, police or court records would show that such crime was promptly reported to the proper authorities, and that the Commission shall consider any police records as well as Romanet 1, the victim's physical, mental, emotional, and family situation, and Romanet 2, the existence of any permanent protective order.
Okay, you've heard the line amendments reported. May I hear a motion?
Move to adopt the amendments.
Is there any questions about, you all have them before you? Hearing no questions, all those in favor say aye. Aye. Opposed? They are adopted.
Thank you, Madam Chair. The Victims' Compensation Fund exists to help ease the financial burdens of victims of violent crime, such as medical bills, funeral expenses, and other costs. However, the current eligibility requirements for victims to file a claim are overly burdensome and prevents them from accessing this assistance when they need it most. As victims go through court proceedings, medical treatment, and sometimes funerals, the 1-year period to file is too short to deal with the application process or even learn in time that they are eligible for the fund at all. Additionally, police reports can hinder victims from coming forward, especially when in instances include domestic violence. So this bill would expand access to the fund for victims who have been historically excluded by extending the timeline for eligibility from 1 year to 3 years after a crime occurs or after a death resulting from that crime. It would also extend the timeline up to 3 years for cases where someone is filing a claim on behalf of a minor or incapacitated person who cannot file for themselves. The bill also strikes language requiring that a police report must be filed within 120 hours of the incident in order for the claim to be eligible, and instead requires the commission to consider police and court records, the victim's physical, emotional, mental, and family situation, and the existence of a permanent protective order when determining if a crime was properly or promptly reported to the proper authorities. And last, the bill strikes language that allows the commission to deny, reduce, or withdraw an award if they find that the victim was not fully cooperative with law enforcement. And that is the bill before you.
Thank you. Are there any questions of the patron? Council, any comments on the bill? Is there anyone in the room wishing to speak for HB 1998? If you all please come forward. It'll be a total of 10 minutes, so you can split it and as you wish.
All right. My name is Robert Voris. I'm here on behalf of the Virginia Coalition Against Human Trafficking. VCAT is an alliance of service providers, attorneys, trafficking survivors, and community members who advocate for victim-centered human trafficking legislation. Traffickers are experts at isolating and manipulating their victims. It often takes years of intensive counseling before survivors fully realize the extent of their trafficking and can develop the trust necessary for them to fully cooperate with police and service agencies. We support extending the deadline for trafficking victims to file a victim compensation claim. This will allow victims more time to work through the complex PTSD experienced by their trafficking nightmare before they must file a claim. We also support removing the requirement that trafficking victims must cooperate with law enforcement to qualify for compensation. This recognizes that trafficking victims are often terrified of trusting law enforcement as they transition from a victim to a survivor mindset. VCAT strongly urges the adoption of HB 1968.
Thank you.
Good afternoon, Madam Chair. Sushila Varkey from Virginia Poverty Law Center, and we support the bill. Thank you, Delegate Delaney.
Madam Chairman, members of the committee, Carter T. Whitelow with Commonwealth Strategy Group, representing the Virginia Sexual and Domestic Violence Action Alliance. We always want to thank Delegate Delaney for her tireless advocacy on this and many issues. We do support this bill. It increases access to funds for survivors of domestic violence and sexual assault, and we believe that added provisions to accept protective orders will increase access to survivors who don't always engage in criminal reporting for various reasons. We stand in solidarity with the Humanization Project in an effort to get this bill passed. Thank you so much.
Thank you.
Good afternoon, Madam Chairwoman and distinguished members of the committee. My name is Gwen Cassidy. I'm with VCOT and the founder of Managing Love. I want to first thank Delegate Delaney for the opportunity to speak on House Bill 1968. This bill represents a critical step forward in supporting crime victims. Trauma does not follow a linear timeline. As a survivor of child sex trafficking and adult labor trafficking, due to the complexity of my neurobiological synaptic development while the trauma was occurring throughout my childhood, I would not remember a single thing until I saw a bad uncle over 30 years later at Thanksgiving as a woman in my early 40s. Victims often face physical, emotional, and systemic barriers that delay reporting or seeking help. Extending the filing period and removing punitive restrictions on reporting delays acknowledges these challenges and shows compassion. It ensures that victims, especially those in fear for their safety, are not denied justice due to circumstances beyond their control. I urge you to pass this bill and help make the system more equitable and accessible for all victims. For all victims, especially children and minors, walking in the footsteps behind me, please, I implore you to do it for them. Thank you, distinguished Delegate Delaney. I am so grateful for you proposing House Bill 1968. My name is Gwen Cassidy, and I thank you for your time.
Thank you. Is there anyone in the room wishing to speak against HB 1968? Seeing no one online, we have from the Humanization Project, Mrs. Fatima Mawahid.
Thank you, Chair Watts, and thank you, Delegate Delaney, for this bill. Re-traumatization leads to underreporting because several steps in the court process reminds the victim of the assault or invalidates the victim's trauma. Only 310 out of every sexual assault are reported to police out of 1,000, 310 out of 1,000. This means more than 2 out of 3 go unreported. This is about equity, so that everyone who needs the funds that VVF has allocated for healing and safety are allocated. So many in our communities harmed but unable to get the help they need because of very real reasons of not wanting to go to the police. This makes it worse for domestic violence situations that only take someone away briefly. 38% of intimate partner victimizations unreported to avoid trouble. This is a negative, there's a lot of negative experience. I am a survivor of sexual and domestic violence who has gone through this specific process. So I understand from a personal angle why this legislation is important. I was forced out of my home because of the person who was doing me harm couldn't get evicted. So this process was very foreign to me at the time, and it was very traumatizing on top of everything else that I personally experienced. It was difficult, it was lengthy, and though I did get some assistance, it was something to help me pay an electric bill at a residence I wasn't even staying at. So I asked the committee to pass this bill, and I thank Delegate Delaney again for bringing this bill. Thank you very much.
Thank you. And before I turn to the next person online, there's been a miscommunication on my part. For someone speaking online, the limit is 2 minutes. And so in recognizing the next speaker, if you could set the clock, please, for 2 minutes. And we have Kate Hanger from the Virginia Victim Assistance Network. Kate?
Thank you, Madam Chair, members of the committee. I'm the Executive Director of the Virginia Victim Assistance Network, and we support this bill. The current time limit of 1 year to file a Virginia Victims Fund claim discourages victims from applying for reimbursement they are entitled to for expenses incurred as the result of their victimization. This is especially true for those victims who are traumatized to the extent that prompt submission of an application to the fund is unduly burdensome. Our hope is that by expanding that period to 3 years, fewer victims will suffer the devastating financial impact of crime. In addition, removing the requirement that victims cooperate with law enforcement when doing so could endanger their lives, protects our most vulnerable victims from further harm due to the lack of access to compensation for the financial impact of crime committed against them. Thank you.
Thank you. And our next speaker is Ms. Jacqueline Goad from the Virginia Coalition Against Human Trafficking. And if you could please turn on your camera. Thank you. That's fine.
Yes, ma'am. Yes. Thank you. I'm very sorry for signing up for everything by accident, Madam Chair and members of the committee. Thank you for having me. I am Jacqueline Goad, a survivor advocate, a labor trafficking survivor with the Virginia Coalition Against Human Trafficking. I wrote a statement and uploaded that as well. I do want to apologize for being overly broad with the brush on law enforcement. I want to acknowledge that there are good law enforcement out there. However, as a trafficking survivor, I repeatedly went to law enforcement in various pockets of Virginia and was not able to get help for me and my daughter's situation. So the removal of the language that requires working with, cooperating with law enforcement, especially from a trafficking side of things, is extremely helpful, is vital, because we are in a situation where we don't know what's going on. And a lot of the times, through no fault of their own, law enforcement doesn't know what trafficking is. And therefore, when you go to them and say, I've been lied to, forced to do things I didn't want to do, and then not allowed to leave, they don't know what that is, and they sometimes end up helping their trafficker, like they did in my case. So I strongly support this bill, and I urge all of you to vote for it. And thank you, Delegate Delaney, for creating it.
Thank you. I believe then you have the final word, Delegate Delaney, on your bill.
Thank you, Madam Chair. I think there's not much more I could add beyond the testimony that you heard today. I think, this is just bringing access to this fund more in line with, a timeline and conditions that I think will best serve the actual needs of survivors here in the Commonwealth.
Thank you. Does anyone on the committee have any questions or comments that you'd like to have before we... The motion is in order then to recommend reporting 1968 as amended.
So moved.
It's been moved and seconded that we recommend reporting. Please open the remote roll. Cast your vote. HB 1968 as amended is recommended to be reported by a vote of unanimous? By a unanimous vote. Thank you. That concludes the docket for today. Stay tuned. There are a lot of bills in the waiting.